Welcome you all aspirants, and this today's particular video we will be discussing the continuation part with respect to our prelims high yield series, which is absolutely important for the preliminary examination. And in the last video we had discussed until Article 30 of the Indian Constitution, speaking of the rights of the fundamental rights for the protection of minority communities. And today we will start from the article number 32, and the question goes like this. What did Ambedkar say about Article 32? Of course, this is very important. Article 32 talks about constitutional remedies. The act or the right to even protect the fundamental right itself is a fundamental right. Okay, so Article 32 was famously called as the heart and soul of the Indian Constitution by the famous Dr. B.R. Ambedkar, as it guarantees remedies for enforcement of fundamental rights. So as we have rightfully discussed, this is the right which protects the fundamental rights, the right that guarantees fundamental rights, which is absolutely required, and hence it is also called as the heart and soul of the Constitution. And now if we have to see what are the key provisions of the Article 32, next question, what are the key provisions of the Article 32? So first one is right to constitutional remedies. Second is Supreme Court empowered to issue writs, means any particular person whosoever gets abrogated or whosoever rights gets abrogated can directly approach the Supreme Court, and Supreme Court in turn is empowered to issue writs. So there are various types of writs, which of course we will study in the next question: habeas corpus, mandamus, certiorari, prohibition, right, quo warranto, all of these things, which we will study in the subsequent questions. Next important feature or provision of Article 32 is the enforcement of fundamental right, which is guaranteed, means Supreme Court ensures that the fundamental right will be definitely safeguarded, and that is the sole purpose of Article 32. Next is Parliament cannot curtail it, which means through any legislation, Parliament does not hold, Parliament or even legislature for that matter, cannot curtail the fundamental rights which is being guaranteed to the citizen of the country by the Constitution, which is also one of the major provision of the Article 32. Next question, can only fundamental rights be enforced under Article 32? Right, these are some of the important questions. Article 32 does not just talk about, or does it only talk about the protection or the enforcement of the fundamental rights? That is a question. Answer is yes. It only talks about the fundamental rights, and only fundamental rights can be enforced under Article 32 and no other right except whatsoever that is. No ordinary law, nothing. Only the fundamental rights, and that too Supreme Court holds the original jurisdiction. However, it is not only limited to Supreme Court. Even High Court has the power to issue writs as a part of constitutional remedies. But also another important thing with respect to your Article 32, you have to keep in mind that Article 32 empowers Parliament to make laws, to give powers to any other courts in the country to issue writs, right? This is under Article 32, and that does not mean that Parliament is giving, or Parliament can make legislation or any particular order for the High Court to issue writs. So that is not covered under Article 32. Why? Because the Article 226 specifically exclusively talks about the High Court's writs jurisdiction. Okay, I hope you clear. You're clear with the point. Let me repeat. Article 32 talks about the constitutional remedies, and also there's one more provision that Parliament is entitled to make certain provisions on the Article 32, or to empower any other court in the country to issue writs, right? And that any other court which we are talking about does not include High Courts. Why? Because High Courts specifically, there is Article 226 which talks about the writ jurisdiction of High Court. So the Article 32 which talks about the Parliament's power to grant any other court to have the, or to issue the power of writs, basically does not include High Court in them, which is very important. And who can make laws on this? It is only the Parliament, who can do it, not the state legislature. So UPSC prelims traps are being set that way, right? So it is the Parliament who can make such kind of laws, and it is only for all the rest of the other courts. And also another important feature of Article 32, you have to keep in mind that Supreme Court's writ jurisdiction is a bit narrowed. On the other hand, the High Court's writ jurisdiction is a bit widened, the scope, right? So that is also important. All these things are mentioned. Please make sure you read it. Compare writ jurisdiction of Supreme Court and High Court. Of course, it's the next question. Supreme Court only fundamental rights, means the Supreme Court's writ jurisdiction, as we discussed, is pretty much narrowed. It means it can only issue writs for the enforcement of the fundamental rights. However, the High Courts, it can issue writs for fundamental rights and other legal rights as well. So High Courts also have wider territorial reach. I hope you are getting the point. And also it is very clear that Supreme Court itself has said that whenever there is a possibility of any solution which the citizens can get when their fundamental rights can get abrogated, they can first approach the High Court and then they can go to the Supreme Court. Okay, so these are all some of the important basic things which you have to keep in mind. Next is, from where are writs borrowed and who could issue them before 1950? Another very important question. So writs are borrowed from England or the English common law, right? English common law. And in fact, if you see, this was first even applied or implemented in the Regulating Act of 1773. Regulating Act of 1773, and it was made enforceable by Calcutta, Mumbai, Calcutta, the old Bombay, and the Madras High Courts, which could issue writs. And this was, as long as 1950, until 1950 or before 1950, these courts were allowed to enforce, or let's say allowed to issue writs as well. Okay, so now what are those writs that we are talking about? First one, habeas corpus, release from unlawful detention or have the body. Okay, and this particular writ is available for those detentions which happen from a private body, or let's say even any government authority or whatever that is, right? Next is mandamus, command to perform the duty. Next is the prohibition, preventing the lower court from exceeding its jurisdiction, and this is usually done by the higher courts. Next is certiorari, quash the illegal order, right? Once again, from the higher courts to the lower courts. Next is quo warranto, question legality of office. If a person is legally holding office, in order to question his legality, so it is the quo warranto which gets issued. So these are also some of the very important areas of the fundamental rights chapter. Every year there has been questions, so please make sure that you know the nook and corners of this each and every writs. It's very important to go in depth in these writ jurisdictions, trying to understand the exceptions as well, right? For example, mandamus can be issued against a private organization, right? Or is it only against the state or any government offices, right? So those kind of intricate details is what is very important to keep in mind. Next is, can habeas corpus be refused and when? Answer is yes, it can be refused when detention is lawful, court has no jurisdiction, detention is under preventive law, and during martial law as well, right? When martial law is in effect. So what is martial law? It is Article 34, right? Article 34 of the Indian Constitution talks about the martial law, and then Article 33 talks about the Parliament's right to frame laws to curtail certain rights of people or those personals, especially who are an army, police, right? All those forces that we are talking about. It is about that fundamental right. Once again, that is also very important. There are important provisions as well, and any law that has to be made to abrogate these fundamental rights of these forces, or let's say these personals, army, navy, and all of those things, even your police and all of those things, it can be only done by the parliament, not the state legislature. There are some of the important aspects. Of course, not the entire article is important, but these things are very crucial to keep in mind. Anyway, moving to the last question, what is the present status of the right to property? Okay, it is currently the legal right under Article 300A, and of course it is not a fundamental right. Do let me know in the comment section as to which particular Constitutional Amendment Act was enacted to remove this from the right to, or let's say this was removed as a fundamental right. Okay, anyway, coming back, property can be taken by authority of law, compensation is not guaranteed, and disputes lie before high courts. And then, very important thing, there are exceptions to fundamental rights. Very, very important, right? So please make sure even you read them and refer to them. Okay, that's all for this fundamental rights chapter. We have covered almost all the 50 questions that pretty much covers the entire fundamental rights. However, now we have some of the important fundamental rights chapters facts, which we will just go through. First is fundamental rights are negative and positive in nature. Of course, this is the features of the fundamental right, because most fundamental rights are negative obligations. See, this UPSC, if they want to ask the prelims, preliminary examination, if they want to ask, they can kind of twist these kind of important facts. So that is what we are going to be discussing now. So most fundamental rights are negative obligations on the state, and some are positive in nature. So maybe UPSC can twist this, right? Like most of it are positive in nature and some of it are negative. Like for example, we have Article 21A, right to education, Article 23, prohibition of trafficking, and Article 17, which talks about the abolition of untouchability. So UPSC likes asking whether fundamental rights are purely negative or they are not. Okay. Next is the classification of fundamental rights itself. So the broad classification is very important. If you have to know, like for example, Article 21, right to life, is a part of what? Is a part of right to freedom, right? Right to equality, all these important articles. Right to equality from Article 14 to Article 18, right to freedom from Article 19 to Article 22, right against exploitation from Article 23 to 24, right to freedom of religion from 25 to 28, cultural and educational rights from 29 to 30, and then right to constitutional remedies in 32, right? So in fact, these are some of the important headers. Most of the students will definitely know what individual articles are, but miss out on understanding which particular right they actually come under. So these are also very important, the important categories of all the fundamental rights. Next is the suspension of fundamental rights. Very important, because there are two important separate articles. First is Article 358, where we talk about the suspension of Article 19 during emergency, and only if emergency is on grounds of war and external aggression. So Article 358, very important. Next is Article 359, where the President may suspend the right to move to courts for the enforcement of fundamental rights, and this except Article 20 and 21, right? So UPSC has been asking questions pretty much on the similar lines. So these two important areas are also very important. Next is Article 19, which only talks about, like let's say, only for citizens, right? Article 19, there are few things, like few articles which are only applicable for citizens of India, and then there are few which are applicable for both citizens of India and the foreigners, and then there are few where these kind of things for enemy aliens, what are the provisions. So those things you have to know. Once again, coming here, Article 19, rights are available only to the citizens, not foreigners. Other rights which are available to both citizens and foreigners include 14, 20, 21, 25 and 23. So this is also one of the important aspect. It is the Article 19 which are available only to the citizens and not the foreigners, keep in mind. Next, we have certain doctrines. I think even when discussing the fundamental rights, we were discussing, especially Article, the very first video, Article 14 and all of those things, the doctrine of eclipse, the doctrine of severability, right? What is doctrine of eclipse? So these are, those particular, it's a particular doctrine which says that pre-constitutional laws which are inconsistent with fundamental rights, right? Any particular law, let's say pre-constitutional laws, like for example, Sedition Act for that matter, or anything related to, let's say, a dowry act for that matter, right? Or how the Domestic Violence Act, right? All of these things which, if is inconsistent with the fundamental rights, they are not fully void, right? They are not completely void, but become eclipsed, right? Revive if inconsistency removed. And these pre-constitutional laws violating fundamental rights void ab initio, means only that particular part which violates or abrogates the present fundamental rights gets eclipsed, right? And this is also kind of one of the important areas of interest, especially for UPSC. So first is the doctrine of eclipse. Next, we also have doctrine of severability, right? If only part of law violates fundamental rights, only that part becomes void, the rest survives. Okay, like we have a fundamental right which talks about a particular law, curtailing certain things, and let's say it is talking about a particular right. Now let's say one particular portion of that fundamental right or let's say one particular portion of that particular law is abrogating the fundamental right, the present fundamental right. So according to doctrine of severability, it says only this part of that particular law becomes void. The rest of the things, it is fine. Okay. Anyway, Article 15 versus Article 16, the difference is very important. Article 15 talks about the access to public places and educational institutions. However, Article 16 talks only about the public employment, right? That is also very important. Next is with respect to reservation and promotions. Very confusing, very important, because the famous Indra Sawhney case, right, in 1992. Originally, it did not allow. It was not allowed under Indra Sawhney case 1992. Later, however, it was allowed via various constitutional amendments, 77th, 81st, 82nd, and 85th. So all of these important amendments are important. See, when studying Lakshmikant, you will be studying all of these categories, all of these important points under various different articles. Okay, under various different articles, and even probably in an entire paragraph, you will study it in probably like 5 to 6 various lines in various areas. So clubbing all of those things and taking one theme based approach. Theme here is reservation and promotions. So under reservations and promotions, you should know the chronology, you should know all those important events. So that is what it is. Okay, so it was originally not allowed under Indra Sawhney case 1992. However, it was allowed in various successive amendments. Which are those amendments? 77th, 81st, 82nd, 85th. So reservations very much in use. So don't be shocked when UPSC or if UPSC asks any questions from this. Next is what are the subject to the subjects to conditions, like all of these reservation. They are based on certain conditions. Which one is the backwardness, if they have any inadequate representation, and then for the administrative inefficiency, administrative efficiency, all of those things. Next is with respect to 50% reservation cap laid down in Indra Sawhney case 1992, and however not an absolute rule, can be extended in extraordinary circumstances. Next is Article 21 itself, the expansive interpretation, which is very important, where we have to know about all those important articles, or let's say important rights that come under Article 21, like right to privacy, the famous case Puttaswamy 2017, and then we have right to livelihood, legal aid, speedy trial, right to clean environment, all of those things, right? Next is preventive detention. So without the advisory body review, I think all of these things we have pretty much read. However, we will just go very faster, like just see an overview as to what is important. Next is Article 24, child labor. All those things. The important ages, for example, the public employment of children below 14 years age, especially in hazardous and dangerous works like factories, mines, and all of the areas where the child is put to danger, right? Those kind of things are absolutely banned. However, not a blanket ban on entire child labor, because child labor also, like let's say, even employing children in some good jobs, for example, hiring them to act in some ad movies, or let's say in some TV shows, all those things are permissible, right? But however, these things, hardest things, very important. So these are the kind of areas which you have to keep in mind, right? Next, we have Article 28, talks about the religious instruction. So completely prohibited only in religious institution wholly funded by state, right? Very important, because there are words aided by the government, partially aided, and wholly funded. Please pay attention there. Next is Article 29 versus Article 30. Even this is also very confusing, because Article 29 protects the interests of any sections of citizens. Okay, it protects the interests of any sections of the citizens, not just limited to the minorities. However, on the other hand, Article 30 talks about only the minorities, right? Only the minorities, and right to establish and administer education institutions for them, right? Next is Article 32, which cannot be curtailed no matter what, because it is itself a fundamental right, right? The right to protect the fundamental right itself is a fundamental right, right? So Parliament cannot take it away. However, it can empower other courts to exercise similar powers. I think we discussed this, and it is only the Parliament which can do it, and it's not the state legislature. Next is writ of habeas corpus. Who can file? In fact, it is like even a third person can file on behalf of a detained person, right? So it is not just the government authority of Supreme Court, all of those things. So these kind of things, see, these are the dimensions with which you have to see the chapters in Lakshmikant. Simply reading it, rote learning will not work in your prelims examination. See, which writ of habeas corpus, who can file? So this is kind of not directly given in the Lakshmikant, but if you just think from that particular angle, you will get the answers, right? So this is the idea to give you, how to read it. Okay. Next is quo warranto, unique features, can be filed by any person, no need to be aggrieved. So basically, you're trying to understand it in a very simpler term, as basic as possible, right? Next is Article 33, special power of Parliament, Parliament and only Parliament and not the state legislature, which can modify fundamental rights for armed forces, police, and all the intelligence agencies, the forces we spoke about. Very important. Often people ignore this. They only think fundamental rights is only till Article 32 and then they are done. But this is also important. UPSC frames questions, on these kind of lines where there are few statements which are, or let's say few provisions which have been given by Parliament and then Constitution. So all of those things, right? So you have to pay attention. Next, Article 35, special legislative powers. Only Parliament can make laws regarding Article 16(3), Article 32, Article 33, Article 34, and Article 35 itself. Like there are few areas. Now UPSC, what they can do is in prelims, they can replace this Parliament just by putting the word Constitution, and that's all they do, right? So please pay attention. It is the only Parliament which can make laws regarding Article 16 subclause 3. Please, do let me know what are these things in the comment section, or if you know, it's really good. Article 32, Article 33, Article 34, and Article 35 itself. So this is, direct prelims area where, this is the kind of ways how it asks. Next is the difference between the martial law and the emergency. There's a beautiful box given in the Lakshmikant where it is clearly given with respect to martial law and the emergency. What is the difference between them? So it is, very important, you have to know. However, martial law, it is not defined in the Constitution, imposed in a specific area. Fundamental rights can be restricted. So these things are very beautifully given in Lakshmikant. Please go check them. Next is the fundamental rights versus DPSPs. This is also important. Fundamental rights are enforceable. DPSPs, of course, it is enforceable to some extent, but it is not justiciable in a way. In a way how fundamental rights are justiciable, right? So DPSPs are not justiciable, but fundamental rights and DPSPs are complementary to each other. This is also very important. And the famous Minerva Mills case clarified the balance. Of course, we will make a separate video on all the important cases. I think that is also very important to know all the important cases which are like the cornerstones of the UPSC, the Lakshmikant textbook, or let's say the Indian polity as a subject. We will make a separate video on that as well. Anyway, next is the horizontal application, very important with respect to articles where, you have 15, 17, 23, very important, you have to know. Next is the Article 300A. Talking about the right to property. It is currently a legal right, it is not a fundamental right, and the compensation not guaranteed, and also with respect to your compensation with respect to any religious institutions. When the government wants to take over any religious institutions, and what is the condition there? The compensation. However, even if the government is giving the compensation, doesn't mean that it completely stops the functioning of that minority education institute, right? So those kind of areas is also very important. I'm not just talking about Article 300. It comes under Article 29 if I'm not wrong. So please go check that also. Article 28, right? Next is cannot approach Supreme Court under Article 32 because it is not a fundamental right. So this is all which is about your fundamental rights chapter. I hope this video or the series of all these 4-5 videos with respect to fundamental rights gives ample potential for you to get at least 90% of the questions correct if fundamental rights, or if there's a question from a fundamental rights chapter. Okay, anyway, that's all for this particular video. I hope you have liked the video. If so, just hit that like button, and do let us know in the comments if you need any more changes in the videos. Probably if you want me to explain things even more in detail, or should I just slow it down, or maybe if you want me to do anything else, you can just let me know in the comment section. Anyway, that's all for this particular video. Signing off, this is Madan Gopal. Have a beautiful day.